we have captured what they said, the National Secretariat and the Honorable Raila Amolo Odinga. The appeal was also supported by the President, and we have captured what was submitted before us by Council in our long judgment. The 19th respondent, Isaac Arwoche, appeared in person, relying on his submissions, which we have also highlighted in our own judgment. The 72nd respondent, Pirista Wakesho, we have also captured what was said in the submissions. We have highlighted the specific parties who opposed the appeals. Mr. Morara Omoke opposed the appeal, supporting the decision of the High Court. The first, second, third, fourth, and fifth respondents represented by Mr. Nelson Harvey and Ms. Esther Angawa also opposed the appeal and relied on their written submissions and made oral submissions, which we have captured in our own judgment. The 7th, 8th, and 9th respondents are represented by Mr. Elias Mutuma, appearing with Ms. Gerono for the 7th to the 8th respondents, also relied on their joint submissions and made oral highlights, which we have captured in great detail in this judgment. The 11th and 12th respondents, represented by Learned Counsel Mr. Elisha Ongoya and Evans Oganda, made submissions in opposition to the appeal. So was Mohori, represented by Ms. Caroline Kituku, made extensive submissions on the issue of the verification of signatures by IBC and also the quorum of IBC. We have captured that. The 79th respondent, Kituo Sasheria, represented by Learned Counsel Dr. Camino, also made extensive submissions, and we also have considered the briefs by the Hamisi, Professor Rosalind Dixon, and Professor David E. Landau, the first and second Hamisi. We have also considered Gautam Bhatia, the third Hamisi, and what he told us in his written submissions on the application of the basic structure. Professor Migai Akich, the fourth amicus, also submitted a submissive brief, which we have summarized on the issues that they raised. Professor Richard Albert, the fifth amici, we have captured the submissions regarding the issue of the basic structure doctrine. And Professor Yaniv Rosnai, the sixth amicus curiae. Professor Charles Manga Forband, Professor Dr. Adem Abebe, Dr. Duncan Ojuang, John Osogo, and Dr. Rinda Musumba also filed a very extensive amici brief with Dr. Jack Mwimari, the Kenya Human Rights Commission also made some extensive submissions on the basic structure doctrine. I have considered all those submissions for and against the appeal, and as observed, the appeals are predicated on Article 163, 4A of the Constitution, which clothes this court with jurisdiction to determine appeals from the Court of Appeal on question of interpretation and application of the Constitution. Although the length and breadth of the pleadings and arguments are summarized, I've touched on several chapters of the Constitution. The common denominator is that they are focused on the interpretation and application of Chapter 16 of the Constitution and how that is to be done. The two superior courts below have traversed and touched all the key provisions of the Constitution. In my view, therefore, this court's jurisdiction is properly seized under that provision of the Constitution. And having set out the issues framed by the court for determination, the 7 issues, I will now proceed to deal with them sequentially. On the basic structure, it is pertinent in the circumstances to point out that the basic structure doctrine, as articulated in the High Court and endorsed by the majority judgment of the Court of Appeal, the sum total of the two decisions being that beyond the 3 stipulated pathways for amending the Constitution provided in Chapter 16, there are certain fundamental features in the 18 chapters of the Constitution that are not amendable without first determining on a case-by-case basis whether a proposed amendment forms part of the basic structure. Further, that any amendment to these particular articles identified as fundamental features of the Constitution would follow a 4 sequential process, being civic education, public participation, and collection of views, constituent assembly debates, and a referendum. In effect, the 2 superior courts below concluded that certain provisions of the Constitution are beyond the reach of enumerated amendment powers stipulated in Chapter 16 of the Constitution. The history of the emergence and evolution of the basic structure doctrine was comprehensively covered in the very detailed judgments of the 2 courts below. Therefore, I will merely mention some of the key features to place my findings in perspective. The basic structure doctrine first received judicial recognition in 1973 in the Kesavananda case, a decision of the Supreme Court of India. The case concerned a challenge to the state government of Kerala's attempt under 2 land reform acts to allow state government to acquire privately held land to fulfill its socio-economic obligations. Subsequently, the Indian Parliament passed the 24th, 25th, and 29th amendments to the Indian Constitution, which in one way or the other shielded Kerala State's land reform acts from being challenged in court. It is in this context that the Supreme Court of India addressed the question of whether there were limits to Parliament's power to amend the Constitution. In a majority judgment of 7 judges with the 6 judges dissenting, the Supreme Court of India held that the 24th, 25th, and 29th Constitutional Amendment Acts passed by Parliament, exercising its powers under Article 368 of the Constitution of India, were unconstitutional to the extent that they damaged the basic structure of the Constitution. The doctrine places substantive remits on the amendment power by placing the basic features of the Constitution beyond the legislative's power to amend the Constitution. In effect, the Supreme Court of India endorsed the idea that a constitutional amendment can be unconstitutional on substantive grounds. I have recited or restated the provisions of Article 368 of the Indian Constitution. And from that provision, it is clear from its reading that the amendment process under the Constitution of India is exclusively vested in the legislature. This therefore means the amendment process of India's Constitution can be described as falling under the flexible model of amendment powers in the flexible regime dichotomy used to categorize the nature of amendment powers in a given constitution. And for this preposition, I have also read books by Zachary Ekins and Richard Albert on making, breaking, and changing the constitutions. Subsequently, the basic structure doctrine and the idea of limits of power to amend a constitution have been considered by courts in several jurisdictions across the world and received mixed reception. For example, the basic structure doctrine and its various variants have been accepted in Bangladesh, Belize, Colombia, Taiwan, Malaysia, Slovakia, and Peru. While courts in France, Georgia, South Africa, Singapore, Zambia, Uganda, and Tanzania have rejected the doctrine. What this state of play demonstrates, which has been recognized by some of the distinguished scholars as reflected in the various materials cited before us, is that the basic structure doctrine has not yet matured into a universal norm of constitutionalism. And for that, I've referred to the writings by Richard Albert, Maukas Makize, and Therese O'Keefe. Given that the basic structure doctrine has not matured into universal norm of constitutionalism or a doctrine of general application, courts have adopted the approach of evaluating its fit within their constitutional systems before accepting its applicability in the various jurisdictions where it has been considered. In Kenyan context, this court has already developed an approach which courts are obligated to follow in ascertaining whether to transplant any juridical idea to the Kenyan Constitution in the post-2010 constitutional order. In the vetting board case, this court grappled with the question of the scope and effect of the ouster of the judicial review power of the High Court by a constitutional ouster clause. Whereas the court considered similar jurisprudence on ouster clauses from other Commonwealth countries that had been inspired by the landmark decision of the House of Lords in the animistic case versus Foreign Compensation Commissions and other. This court developed the interpretive model to be followed. In that case, the vetting board. I have considered the dictum in that case and the imposed obligation by this court under Section 3C of the Supreme Court Act, which provides that we must develop rich jurisprudence that respects Kenya's history and traditions and facilitates its social, economic, and political growth. Accordingly, before declaring the applicability or otherwise of the basic structure doctrine in Kenya's constitutional context, a court is obligated to take into account our constitutional history, especially bearing in mind that the doctrine, which found roots in 1973 in India, was available when the framers of the Constitution of Kenya conceptualized the provisions of Chapter 16 on amendments. Another way of looking at the matter is to ask a pertinent question as to whether there are gaps identified in particular in regard to the provisions of Chapter 16 of the Constitution requiring to be sealed by the basic structure doctrine. In addition, in evaluating whether the basic structure doctrine is applicable in our constitutional system, a court must take into account the purposive and value-based interpretation decreed by Articles 10, 20, 4, 159, and 259(1) of the Constitution. Such an approach to constitutional interpretation begins from and remains rooted in the text of the Constitution, whilst interpreting it holistically, giving effect to its values and principles, and never losing sight of the historical context and the backdrop of the provisions being interpreted. Therefore, to comprehend and contextualize whether the Constitution contemplates the basic structure doctrine, the starting point should be the rationale behind the provisions of Chapter 16 as documented in the preparatory documents from the constitution-making process. It is an understatement to say that Kenyan independent constitution endured a legacy of hyper amendments during the post-independent period. The former constitution was flexible, giving the legislative wide power and discretion in amending it. As a result, Parliament undertook so many amendments to the Constitution that it lost its original character. The most significant amendments being the merger of the Senate and the House of Representatives to establish a unicameral legislature, abolition of the quasi-federal regional governments that led to the establishment of a unitary state, and alteration of the entrenched majorities required for constitutional amendment, making it easier to amend the Constitution. Yet another repulsive amendment was the abolition of the security of tenure for judges and other constitutional office holders. Ultimately, the amendment that finally broke the proverbial camel's back, giving rise to the clamor for a new constitutional order, was the one that converted the country from a multi-party democracy to a de jure one-party state in 1982. Informed by this history, Kenyans yearned for a stable constitutional system where the power to amend the Constitution would not be abused for short-term interests by political elite. The CKRC report records at page 74 that Kenyans expressed what they wanted, and I quote, "There is a need to protect the Constitution against indiscriminate amendments." What emerges from the historical account is that there was a strong concern that the country should adopt provisions on amendment power that are able to protect the constitutional order from abusive amendments. But this was not all. There was also a recognition that the Constitution must remain flexible in order to adjust to political, social, economic, technological, and other changes that take place in the polity. In effect, the overarching imperative that informed the drafting of Chapter 16 was the need to find a proper balance between rigidity and flexibility. The quest for a balance between rigidity and flexibility is evident in the tiered amendment provisions in Chapter 16, which stipulates 3 pathways for amending the Constitution. The first pathway, under Article 256, provides for amendment by parliamentary initiative. This process involves public participation and approval by the Houses of Parliament through a vote of endorsement by 2/3 of all members of each House during the second and third reading of the amendment bill. The second pathway, under Article 257, provides for amendment by popular initiative. This process involves collection of at least 1 million signatures from registered voters in support of the popular initiative by the promoters of the initiative. Approval of the initiative by the majority of the county assemblies, and passage of the bill by the majority of the members of each House of Parliament. In this second process, if either House of Parliament fails to pass the bill, the proposed amendment is submitted to the people in a referendum. The third pathway under Article 255 relates to what has come to be known as the entrenched provisions of the Constitution. Some of the Court of Appeal judges referred to these entrenched provisions as forming the basic structure of the Constitution. Article 255(1) of the Constitution stipulates that in addition to adopting either the parliamentary initiative or popular initiative pathway, where an amendment relates to the following articles, a bill to amend those provisions shall be subjected to a referendum. These are the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, the national values and principles of governance in Article 10(2), the Bill of Rights, the term of office of the President, the independence of the judiciary and commissions, and independent offices, to which Chapter 15 applies, the functions of Parliament, the objects, principles, and structure of devolved government, or the provisions of Chapter 16 on amendment of the Constitution. Approval through the envisaged referendum under Article 255(2) must satisfy two conditions. At least 25% of the registered voters in each of at least a half of the counties should vote in the referendum, and such an amendment should be supported by a simple majority of the citizens. A reading of the three pathways for amending the Constitution in Chapter 16 clearly shows that Kenyans were alive to the historical legacy of the culture of Article 255(1) and 2 of the Constitution demonstrates that, alive to the culture of our hyper amendments, the Kenyan people sought to ring-fence the core fundamental commitments of the Constitution by entrenching them and subjecting the process of amendment to deepened public participation, as well as imposing a downstream constrained veto by stipulating that the entrenched provisions enumerated in Article 255(1) of the Constitution can only be amended through a referendum process. The rationale of entrenching the provisions mentioned in Article 255(1) of the Constitution is, in my view, informed by the very democratic idea that constitutional amendments of a fundamental nature should take place through a deeply participatory process and be ratified by the people, being the ultimate sovereign of the polity, through a referendum. The approach in balancing flexibility and rigidity in constitutional amendment adopted in Chapter 16 reflects and compares favorably with modern constitutional architecture and design. Drafters of contemporary constitutions pursue the goal of balancing rigidity and flexibility through what has been termed as tiered design amendment rules. This argument is augmented by the articles cited before us by Professor Rosalind Dixon and David Randau in their writing titled Tiered Constitutional Design. Under the tiered constitutional model, amendment rules vary with provisions that are core to fundamental to constitutional systems being placed on a higher tier and made more difficult to amend. The amendment rules under the Constitution adopt this modern tiered constitutional design, combining combining the virtues of rigidity and flexibility by having different amendment procedures applied to different foundational values, principles, and structures of the Constitution have been granted a higher level of entrenchment to ensure the stability of the constitutional system. It follows, therefore, that Kenyans were conscious of the core constitutional values, principles, and structures that they wanted protected from abusive amendments, and they protected them through entrenched provisions of Article 25 of the Constitution. In my view, therefore, the framers of the Constitution, well aware of the basic structure doctrine, chose to ring-fence some key features from flexible amendments. And if it was their intention to provide for eternity clauses or the basic structure doctrine, nothing would have stopped them from doing so. The next question that follows is whether it was necessary for the two superior courts to adopt the basic structure doctrine and thereby devise a fourth-way path for amending the Constitution outside the three pathways that are stipulated in Chapter 16. To answer this question requires one to appreciate how the High Court and the majority of the Court of Appeal judges proceeded to analyze Chapter 16. It was on the premise that based on the history of IPAR amendments of the repealed Constitution during the pre-2010 dispensation, the Constitution demanded heightened procedures beyond the tiered design of the amendment procedures provided in Chapter 16 that would make the Constitution more difficult to amend. The two courts, therefore, did not go into a detailed analysis and to specifically point out the actual shortcomings of the provisions of Chapter 16, especially in light of all the prolonged and successful attempts that have been made over time, over the last 10 years, to amend the Constitution. The Court of Appeal, in my respectful view, and a duty to analyze the findings of the High Court and specifically point out whether there were apparent inadequacies as far as the provisions of Chapter 16 were concerned. Looking at the history, as stated above, as well as the provisions of Chapter 16, it is clear to me that Kenyans sought to achieve a balance between rigidity and flexibility in the amendment process. Kenyans do not want to shift from one extreme of IPAR amendment to another extreme where no amendment can take place. That is from IPAR amendment to ultra rigidity in the amendment process. Rather, what Kenyans desired is a balance between rigidity and flexibility, as reflected in the tiered amendment process in Chapter 16 of the Constitution, with the core or essential features of the Constitution being accorded heightened
Alizilishi Evangelism Center San Musao, neno evangelism, kitano mkubwa wa Injili na ukombozi, 13. Joni nyote mliolemewa na mizigo,
through ratification in a democratic process in the form of a referendum. The High Court and the majority of the Court of Appeal, with tremendous respect, failed to appreciate that the tiered amendment process is one of the options available in the menu of constitutional designs options for dealing with the practice of abusive amendments, just like other designs options limit amendability. For example, eternity clauses and basic structure doctrine. Therefore, where Kenyans have selected the tiered amendment procedure as their response to the culture of hyper amendability, I find it difficult to justify this judicially created fourth pathway of amending the Constitution founded on the basic structure doctrine. Unfortunately, there was no justification provided to demonstrate the lacuna in the Constitution and hence the need to call in hand the basic structure doctrine to enhance the existing tools of interpretation. The 2010 History of Kenya is replete with precedents of application of foreign laws and doctrines from Commonwealth and other jurisdictions, which was done due to absence of local statutes. Today, I dare say that courtesy of our Constitution, we have sufficient arsenals that include our own canons of interpretation, which we must exhaust before borrowing from other jurisdictions. Further, I see a potential conflict within the constitutional system with the judiciary created fourth pathway for amending the Constitution.
It has to be short term.
That in
It
our
cannot be long.
constitutional dispensation that is
Kenyan
people-centered,
electricity power plant.
our
Now,
nascent
this they say
democracy
will set in
that
motion
respects the
activities to
doctrine
add
of
to its
separation of powers
national
by
power.
vesting
Kenyans
legislative
MD
power
and
in the
to
legislature
drive Kenya's
to create
economic
a
Thermal
fourth
energy can be
pathway
used for
within
heating
the scheme
and
of
cooling, but
amendments
Kenyans
would bring
come
into
from the
question
all-carrier
the place
geothermal
of the
fields in
participation of the
Nambashmo power
people
plants,
and the
Area
place
2,
of the
all-carrier
legislature
4,
in that scheme.
and Eburi.
Taking into account
Julie Wambui,
where we are at
Now,
in
the
our
national-
constitutional democracy,
some of
Kenyans
the geothermal
needed
power
to be
plants owned
consulted
and operated by
on whether
Kenyan
it is their
include
wish
all
to
carrier 1
introduce the fourth
and
pathway
cooling purposes,
for
or be
amending
harnessed
the
to generate
Constitution.
or steam
In
carry
other
the
words, we
geothermal energy
judges should
to
be
the Earth's
vigilant,
surface.
lest we are
Depending on
accused of
its
usurping the
characteristics,
sovereign power
geothermal energy
vested
can
in
be
the
used for
people by
heating and
introducing
cooling
a
purposes,
constitutional
or be
amendment
harnessed to
through
generate clean
judicial fiat.
electricity.
Put differently, the tiered amendment process provided in Chapter 16 of the Constitution is a design option for dealing with the problem of abusive amendments and obviates the need for judiciary-created limits to amendments' power, like the basic structure doctrine. This is in line with the view expressed by Professor Rosalyn Dixon and David Randall. My take home from this scholarly perspective is that tiered design of constitutional amendment process is one of the design options used to curbing the problem of hyper-amendments. Professor Rosanai rightly points out in his well-balanced amicus brief that the applicability of the basic structure doctrine depends very much on the context. The most important contextual consideration is the balance between flexibility and rigidity of the amendment process. The more difficult the amendment process, the less there is need for a doctrine of limits to amendment power. The jurisprudential underpinning of this view is that in a case where the amendment process is multi-stage, involves multiple institutions, is time-consuming, engenders inclusivity and participation by the people in deliberations over the merits of the proposed amendments, and as downstream veto by the people in the form of referendum, there is no need for judiciary-created implied limitations to amendments power through importation of the basic structure doctrine into a constitutional system before exhausting homegrown mechanisms. Moreover, I fully agree with a portion of the judgment by Sishare J, where she questioned the viability of relying on judges to interpret on case-by-case basis on whether a particular provision of the Constitution is amendable. To put this into perspective with respect to our constitutional architecture, amendment of entrenched provisions of the Constitution relating to the matters listed in Article 255(1) through popular initiative route requires, first, there must be public participation throughout the amendment process by dint of Article 10(2) of the Constitution. Second, collection of 1 million signatures from registered voters in support of the initiatives as provided in Article 257. Third, support of the initiative through approval of the bill by a majority of the county assemblies as stipulated in Article 257(7). Fourth, consideration of the bill by the bicameral House of Parliament, Article 257(10). Fifth, subjection of the bill to a referendum in terms of Article 255, in which at least 25% of the registered voters in each of at least half of the county's vote in the referendum, and the amendment is supported by a simple majority of the citizens voting in the referendum. 6, it should also be appreciated that the processing of the bill in the county assemblies and the bicameral houses of parliament is also subject to a further public participation requirement in terms of Article 196 and 118 respectively. 7th, Article 88.4G imposes an obligation on voter education on IEBC. Amendment of the entrenched provisions under parliamentary initiative routes by dint of Article 10.2 of the Constitution requires public participation, which must inform the entire amendment process. Second, the amendment bill has to go through the bicameral house. Looking at the two pathways for amending the entrenched provisions, it is inescapable to conclude that amending the core of fundamental provisions of the Constitution is a multi-staged, multi-institutional, time-consuming process that ensures that a constitutional amendment process that touches on the core of the fundamental aspects of the Constitution is transparent, inclusive, engenders the participation of the people in a democratic society where they decide their own governance. I therefore find that the tiered amendment process under the Constitution meets the set criteria as to when judiciary created basic structure doctrine is inappropriate and undesirable. Therefore, the two courts below and by finding a fourth judiciary created pathway for amending the Constitution, which is with respect tantamount to amending the Constitution through the judgment of the court. To buttress the point of tiered amendments, post-2010 Constitution, the amendment practice post-2010 Kenya Code illustrates that the tiered amendment design is an adequate bulwark against abusive amendments. As pointed out by Sishare J. in a dissenting opinion at the Court of Appeal, there have been 21 failed attempts to amend the 2010 Constitution during the first decade of its operation. 19 of these were through the parliamentary initiative and 2 were through the popular route. It is also notable that although the amendment bill had gone the farthest in amendment process, it was yet to be subjected to the ultimate downstream veto of the referendum process. Comparatively, the Independence Constitution had undergone 12 major amendments by its 10th birthday. In essence, it is right to conclude that the resilience of the 2010 Constitution in its first decade is proof that Kenyans attained the goal of balancing flexibility with rigidity in designing the amendment power as reflected in Chapter 16 of the Constitution. It ought also to be appreciated that judicial protection of implied limitation to the amendment power, such as through the basic structure doctrine, become increasingly required in context where the country has two flexible constitutions that can be amended fairly easily. Therefore, while it was inappropriate in the pre-2010 dispensation for the High Court, Ringera J, as it then was in the Joya case, to recognize the basic structure doctrine under the repealed Constitution, there is no such need under the 2010 Constitution. This view is founded on the premise that the risk of abusive amendments has been tamed by the tiered amendment process that entrenches the core of essential provisions through a heightened, elaborate amendment process. Considering the progressive nature of the Constitution, a three-judge bench, Korir, Goge, and Odinga in Kisira Dururu case, expressed skepticism as to the continued relevance of owning the Joya case on the basic structure post-2010 Constitution in light of the provisions of Article 255 of the Constitution. In contrast, the unique context of India, with a too flexible constitution that grants the legislature the wide discretion in amending the constitution, arguably justifies the judge-made basic structure as developed and practiced in India in order to stabilize the constitutional order and prevent the practice of abusive constitutional amendments, given the low threshold for amendments in the text of the Constitution, just as it was in our case prior to the 2010 Constitution. Although I think I've said enough to demonstrate why I disagree with the judgments of the majority of the Court of Appeal bench regarding the application of the basic structure post-2010 constitutional order, I will briefly highlight some of the critical aspects which were not considered by the two superior courts, and if the judges had done so, perhaps they would have come to a different opinion. Number one, the superior courts failed to appreciate that the concern with the culture of IPA amendment had already been taken into account during the drafting of the Constitution of Kenya 2010. This led to the design of the tiered amendment process that balances flexibility and rigidity. In such a context, the correct judicial culture ought to have been fidelity to our Constitution. This is informed by the reality that the Constitution, to a large extent, is self-contained and self-regulating in dealing with the legacy of abusive amendments in the former constitutional amendments. Therefore, there is no justification for courts to go outside the four corners of the Constitution to create a fourth pathway for the amendment of the Constitution. Number two, the Court of Appeal failed to analyze the provisions of Chapter 16 and to arrive to its own independent conclusion on the shortcomings of the three-tiered process, and to state clearly whether it was necessary to call in aid a foreign doctrine. Also, to take into account the amendment practice in the post-2010 dispensation in the analysis of the Kenya's constitutional history, which shows that Chapter 16 of the Constitution has brought stability in the constitutional system in contrast to the culture of hyper amendment under the former Constitution. There have been multiple attempts to amend the Constitution, which were all unsuccessful, meaning that the amendment process is not flexible, as in the Indian case. Three, the Court of Appeal failed to take into account the fact that Chapter 16 is one of the entrenched parts of the Constitution under Article 255(1) of the Constitution. Therefore, it could not be amended by the courts through created fourth pathway of amending the Constitution without following the constitutionally ordained amendment process provided for under Article 255(1) of the Constitution. And fourth, the Court of Appeal failed to appreciate that Kenyans were aware of the idea around the basic structure doctrine during the Constitution making face in light of the legacy of the case of Joya, and yet did not embrace the idea of a veto to the amendment power as represented in the basic structure doctrine, as well as related to doctrines like eternity clauses. The CKERC report on page 76 indicates that Kenyans yearned for power to have a say in amending the core fundamental features of the Constitution through a referendum and an inclusive and participatory process. This was done through the provisions of Article 255 of the Constitution. Another aspect of the majority judgment of the court that I need to address relates to how the two courts treated the historical background informing the drafting of Chapter 16. It is evident that the decision on the question of the application of the basic structure and doctrine within Kenya's constitutional system was largely turned on historical inquiry to clarify and provide interpretative guidelines on the intent of the Kenyan people during the drafting of the Chapter 16. While this court has in the past celebrated the virtues and utility of the historical context, the background to the adoption of the Constitution in the Constitution interpretation is imperative. Given the subjective nature of the historical narratives, courts should endeavor to extract and have a view of the complete account of the historical background to the constitutional provision being interpreted. Where a court embraces an account of history that marginalizes, excludes, or suppresses or omits some portions of history account, such an incomplete history distorts or rather fails to illuminate the meaning of the constitutional provision being interpreted, hence misleading the court to reach an erroneous conclusion. Before leaving this part, I will also address the argument advanced by Dr. Kaminwa that the basic structure doctrine is applicable in Kenya pursuant to the provisions of Article 2(5) of the Constitution. The provision reads, and I quote, "The general rules of international law shall form part of the law of Kenya." This court has already provided juridical interpretation of Article 2(5) in the case of Mitubel, where it was held, and I quote, "In light of the foregoing, we hold that the once general rules of international law in Article 2(5) of the Constitution refer to customary international norms, including jus cogens. There is a general acceptance that customary international law requires, in the words of Article 38(1)(b) of the Statute of International Court of Justice, a general practice accepted as law. That is both sufficiently widespread and consistent practice and what states have accepted as law, opinio juris, accompanying it. Examples of customary international law include the doctrine of non-refoulement of refugees and granting of immunity for visiting ends of states. Since the basic structure doctrine is a constitutional law principle acceptable in just a number of states and not an international law principle, it does not amount to a customary international law principle. Therefore, Article 2(5) of the Constitution cannot be the basis for founding the applicability of the basic structure doctrine. In the end, I find that the basic structure doctrine and the 4 sequential steps for amendment as prescribed by the High Court and the majority of the Court of Appeal are not applicable in Kenya under the Constitution. Any amendment to the Constitution must be carried out in strict conformity with the normative standards and provisions of Chapter 16 of the Constitution. I will now move to the second issue, whether the President can initiate amendments to the Constitution through a popular initiative. The question raised was whether the President could initiate the amendment and popular initiative routes provided for under Article 257 of the Constitution. Like other norm-producing process, a constitution amendment process starts with an initial decision. That is the initiation or activation of the process. The initiative speaks to how the amendment process starts. The story starts with the 8th August 2017 presidential elections, in which the president was declared by IEBC as having been duly re-elected for a second term in office. The election results were challenged before the Supreme Court by Right Honorable Raila Odinga, who had been declared as the runner-up to the presidential elections. The Supreme Court annulled the results through a majority decision delivered on 1st September 2017 and ordered fresh presidential election be conducted within 60 days of the nullification. However, the Right Honorable Raila Odinga and his political coalition, the National Super Alliance, withdrew from participating in the fresh presidential election, which took place on the 26th October 2017. Subsequently, Right Honorable Raila Odinga and the NASA coalition vowed not to recognize the government that was formed as a result of the fresh presidential election. This led to some incidents of violence that brought about tension in the country. After months of tension, the President and the Right Honorable Raila Odinga, in an act of statesmanship, patriotism, and bipartisan accord, emerged on 9th March 2018 to announce to the public that there was cessation of hostilities between the two political sides in what they called a handshake through a joint communique, building bridges to a new Kenya. It is in the quest to implement this noble objective of promoting national unity and overcoming other challenges identified in the joint communique that the President appointed the Building Bridges Task Force. On 26 November 2019, the BBI Task Force released their report, which was unveiled to the public. On 10th January 2020, the President appointed the BBI Steering Committee with the terms of reference that were stated therein. As far as the President's actions with respect to setting up the BBI Task Force and BBI Steering Committee to further the agenda of promoting national unity were concerned, in my view, these actions cannot be faulted. Indeed, they are roundable acts of statesmanship executed within the ambit of the provisions of Article 131(2)(c) of the Constitution. This article demands nothing less from the President, as it directs the holder of that venerable office to promote and enhance the unity of the nation. However, it is important to clarify that the legal constitutional question before this court does not go to the propriety of the pursuit of the Building Bridges to Unity project. The question before the court is a narrow one, and it relates to whether a constitutional amendment process initiated by the President can be pursued through a popular initiative route prescribed in Article 257 of the Constitution. To answer the question as to who may initiate an amendment process through a popular initiative requires that we understand the purpose that is intended to be served by introduction of the popular initiative as a route for amending the Constitution. This is pursuant to the purposive interpretation decreed by Article 259 of the Constitution. The constitution-making history that I have highlighted demonstrates that a popular initiative was a tool carved out exclusively as a route for constitutional amendment by citizens. In essence, amending the Constitution through a popular initiative was intended to be a citizen-driven and a citizen-centered process. The citizen-centric nature of a popular initiative is linked to the fact that it is conceived as a means for direct sovereign power to be expressed as contradistinguished with the parliamentary initiative, which lies to the realm of the derived or delegated sovereign power. Under this understanding, the popular initiative is supposed to be triggered from below at the initiative of the citizenry, as opposed to representative institutions. In other words, the popular initiative is intended to give citizens acting outside the institutions of the state a means to activate or trigger the exercise of their sovereign power. This understanding of the centrality of the citizens in activating a constitutional amendment process through a popular initiative is projected in the book that was referred to us by Joe Coron Lois, titled Constitutional Power and the Law. My analysis of Article 257, the history of constitution-making process, and the authority cited in the said book, although persuasive, indicates that a popular initiative is an exercise of direct sovereign power that excludes the representative institutions, that is, the legislature and the presidency, which only exercises power that is derived or delegated sovereign power as distinguished in Article 1, 2, and 3 of the Constitution. In other words, it is a means of direct democracy, and indeed direct democracy can only be exercised by the people, not their representatives, since that would convolute the form of democracy at play. It follows, therefore, that a popular initiative in a constitutional amendment process ought to be seen as an avenue through which citizens engage in the exercise of their sovereignty. As such, state organs, being not bearers of direct sovereignty, have no right to activate the popular initiative. This leads to the conclusion that the popular initiative is a preserve of the citizens, the one popularly known in Kenya as the Wanjiku. It ought to be appreciated that the Constitution provides normative markers for how, when, where, and by whom particular powers are to be exercised. Article 257 delineates who has the power to undertake what duty or obligation as a right to undertake specific measures with respect to the constitutional amendment process. It is in appreciation of this that I need to interrogate the argument that the institution of the presidency has the authority to initiate a popular initiative in light of the overarching right motive of the Constitution, which is concerned with tampering or limiting the powers of the presidency. In its architecture and design, the Constitution strives to provide explicit power to the institution of the presidency and at the same time limit the exercise of that power. This approach of explicit and limited power can be understood in light of the legacy of domination of the constitutional system by imperial presidents in pre-2010 dispensation. As a result, Chapter 9 of the Constitution lays out in great detail the powers and the authority of the president and how such power is to be exercised. Another reason that supports the finding that the president was not envisaged as an initiator of a popular initiative is the role of the president with respect to entrenched matters listed in Article 255, 1 of the Constitution, Article 256.5 as read with Article 257.10 of the Constitution, which grants the president a law that can be typified as serving as the guardian of the amendment process. In that, where a constitutional amendment bill is presented for assent, the president has the obligation of reviewing the bill and referring the bill to undergo a referendum process where it involves matters listed in Article 255 of the Constitution. Such a guardianship role over the amendment process ought not to be undertaken by the player in the amendment process. I therefore endorse the finding by the two superior courts that the president ought not to be both a player and an umpire in the amendment process. The last reason for finding that state institutions and presidents are excluded from using the popular initiative is to be found in Article 255, 3B of the Constitution. It shows that the Constitution recognizes a distinction between the people, the state bodies like Parliament. It therefore follows that a state body like the institution of the presidency cannot fall within the rubric of the people, as the very text of the Constitution makes this distinction. This leads me to the inescapable conclusion that state institutions and state organs, such as the presidency, cannot initiate constitutional amendments via the popular initiative route provided for under Article 257 of the Constitution. Nonetheless, this finding does not dispose the issue, as counsel for the president and even the Attorney General sustained an argument that barring the president from initiating or pursuing constitutional amendment process through a popular initiative was a violation of the president's political rights as protected for in Article 38(1) of the Constitution. Given that a process to amend the Constitution is a democratic process which is meant to give effect to self-government, the limitation and promotion of an initiative to change the Constitution is a political choice protected under Article 38(1)(c) of the Constitution. However, there is an additional angle in deciding whether a right is applicable in a given factual situation. This is the concern with the rights range of application as provided in Article 22 of the Constitution, which provides every person shall enjoy the rights and fundamental freedoms in the Bill of Rights to the greatest extent consistent with the nature and the right of the fundamental freedom. What I deduce from this provision is that a court is under an obligation to interrogate whether a person arranging a violation of a right is actually a beneficiary of that right in question. In this context, it is notable that Article 38(1) grants the freedom to make the political choices to every citizen. The citizen qualifier speaks to the range of application of the freedom to make political choices by limiting the rights enjoyments to the citizens. Therefore, for one to be a beneficiary of the freedom to make a political choice, they must fall within the category of the citizen. Based on the citizenship qualification, the freedom to make political choices is a right that does not accrue to state organs or institutions. State organs or institutions cannot be citizens because under Chapter 3 of the Constitution, citizenship is limited to living human beings, excluding state organs. Consequently, while the president, when acting in his private capacity as a citizen, can enjoy freedom to make political choices, this right does not accrue to the institution of the presidency, which is a state organ. The presidency and other state organs do not fall under the rubric of citizens. I therefore find that exclusion of the institution of presidency and other state institutions from initiation of a process to amend the Constitution through the popular initiative route does not violate the political rights protected under Article 38(1) of the Constitution. The last aspect of this issue relates to whether it was established through evidence that the process to amend the Constitution through amendment bill was initiated by the President. At the outset, it should be pointed out that the concurrent findings by the two courts below was that the President, by a number of antecedent acts, and initiated the process, and the state was the real force behind the amendment process, including through the use of state resources to support the process. In a challenge to this finding, it was argued by the Attorney General and the BBI National Secretariat that it is the BBI National Secretariat through Honorable Dennis Wawero and Honorable Junet Mohammed who are the initiators and promoters of the impugned constitutional amendment initiative and not the President. An examination of the evidence before the courts revealed a number of things relevant to this factual determination. For starters, the President and the National Executive took certain actions which portray its role in the initiation and promotion of the constitutional amendment. The President did not do those things as a private citizen, and this is clearly demonstrated in a number of ways. One, the President signed off the communique in March 2018. The official title of the President. The communique was published in a paper bearing the coat of arms of the Republic and the seal of the President. The President appointed the BBI Task Force and the BBI Steering Committee Task Force through Gazette Notice of 51, 54, and 264 of 2018, respectively. The President received the official reports through a state function as President. As a result, it cannot be disputed that the President was involved in the initiation of the amendment bill. However, in my considered view, the President cannot be blamed for this because it is the promoters who took over the amendment bill under the auspices of the BBI National Secretariat, who had, by invoking the popular initiative route under Article 257, to pursue the amendment process. It is my finding that the genesis of the amendment bill can be traced to all these actions. I therefore affirm the factual findings by the two superior courts that the president was involved in the amendment bill and agree with the finding by Tuyot J. I believe I have stated enough to support by conclusion that the president of the state institutions are not permitted to initiate or promote a constitutional amendment process through the popular initiative route envisaged in Article 257 of the Constitution. This now takes me to the third issue, whether the second schedule to the amendment bill was constitutional. To put this question in context, it ought to be appreciated that the second schedule was intended to serve as a transitional scheme of implementing Clause 10 of the amendment bill. Clause 10, which intended to amend Article 89 of the Constitution, provided, and I quote, Article 89(1) of the Constitution is amended by deleting the words 290 and substitute therefore with words 360. Clause 1(2) of the second schedule proceeded to distribute the additional 70 constituencies as per the schedule. It is in the above context that the constitutionality of the second schedule, directly allocating and apportioning the proposed constituencies to specified counties, were challenged. The two superior courts were unanimous in their findings that the second schedule to the amendment bill was unconstitutional. This finding was based on the substantive grounds that the second schedule violated the basic structure of the Constitution by purporting to take away the mandate of the IEBC, an independent body under the Constitution. Further, it was contended that the second schedule impermissibly directed IEBC on the execution of its constitutional functions. It is imperative to begin the analysis on the constitutionality of the second schedule of the amendment bill by pointing out that given my earlier finding that the basic structure doctrine does not apply under the Constitution of Kenya 2010, my determination of this question rests on the procedural concerns linked to whether there was public participation in coming up with the second schedule. This is because the provisions of Article 89 are amendable as long as due process is followed. It ought to be appreciated that amendments touching on matters falling within the remit of Article 255(1), which are the core fundamental commitments of the Constitution, ought to be undertaken through a highly participatory and inclusive process. It should be noted that directly allocating and apportioning constituencies usurps the mandate of IEBC, an independent constitution commission, removing the possibility of judicial review of the delimitation as an effect on the independence of the judiciary. The centrality of the constituencies as units of political representation in the National Assembly means that they ought to be apportioned and allocated by a neutral and professional actor, much more so because malapportioned constituencies have the potential of diluting the power of the votes, hence threatening the animating goal of fair and effective representation, which is at the heart of the foundational value of democratic governance enshrined in Article 4(2) and 10(2)(a) of the Constitution. Further, since the constituencies are units of social and economic development through allocation of national government constituency development fund, and the recruitment into disciplined forces such as the Kenyan Defense Forces and the National Police Service, the delimitation of constituencies has implications on the constitutional values and principles of equity and social justice enshrined in Article 10(2)(b) of the Constitution. It goes therefore without saying that the delimitation of constituencies must be accompanied by a process that is fair and just, which is the golden thread that runs through our constitutional order as elaborated in the preceding chapters. I've also considered that this process was not subjected to public participation and referred to cases by this court, the British American Tobacco case, that provided that the tests for adequate public participation should be reasonableness. That should be the threshold. Following from this case, I now examine whether there was reasonable notice and opportunity afforded to the public for generating the views and deliberating on apportioning and allocating the disputed 70 constituencies as provided for in the schedule. An examination of the process leading to the BBI task force and the BBI steering committee reflects that there was reasonable participation and involvement of the people in coming up with the recommendations of the bill that was published on 21st October 2020. There is, however, no evidence of any form of public participation or deliberation between 21st October 2020 and 25th November 2020 when changes to the draft constitution of Kenyan bill was made, including the addition of the second schedule. This leads, therefore, to my conclusion that the constitutional threshold of reasonable public participation was not met when the second schedule of the amendment bill was presented. Consequently, I come to the conclusion that the second schedule of the amendment bill is unconstitutional for want of public participation, a constitutional obligation that flows from Article 10(2) of the Constitution. I move now to the fourth issue on the presidential immunity. At the outset, it is important to point out that given the Court of Appeal held that the President was not served with the petition number E400 of 2020 in the proceedings before the High Court in which this question arose, it was improper for the Court of Appeal to proceed and adjudicate the question of interpretation of Article 143(2) of the Constitution. However, as considered in the President's written submissions filed before the High Court, there is a public element in this matter, so this court should clarify and settle the law on the nature and scope of protection of the President from civil legal proceedings, considering the findings of the two courts below. It is generally recognized that immunity from legal proceedings usually takes two forms. First, immunity from liability protects officials, not from proceedings being undertaken, but from personal liability at the end of the proceedings, which relates to enforcement. Second, immunity from proceedings is a broader form of immunity that overthrows the court's or tribunal's jurisdiction to hear a matter because the parties against whom the proceedings are undertaken enjoys immunity. Further, there is absolute and qualified immunity. Absolute immunity has no limitation as to its application, while qualified immunity usually has limitation, like extent of actions and other related to other official function, whether done lawfully or done in good faith. The Constitution contemplates immunity of certain officials in the performance of their functions. For example, Article 160, a member of the judiciary; Article 250, a member of the commission; Article 143, criminal proceedings shall not be instituted; against the president or a person performing the functions of that office during the tenure. From the structural ending of the above provisions, there are glaring distinctions that illuminate the nature and scope of presidential immunity envisaged under Article 143(2) of the Constitution. Firstly, all the officials set out above enjoy immunity as persons, holder of office or member of a commission, but not their offices. Whereas the president enjoys immunity as both the person in the office and the office itself. This is evident from the choice of phraseology used in Article 143 to the effect that the president or the person performing the functions. To make the point clearer, one can contrast the nature of immunity envisaged in Article 143 to Article 259 for an holder of an independent office. Consequently, this brings me to the inescapable conclusion that the immunity of the president is unlike that of the other state actors. The president not only enjoys functional immunity like all public officials who perform state duties, which protects them from civil liability for official functions, they further enjoy sovereign immunity as the end of state and the single representation of the sovereignty of the Republic. Indeed, it is only sovereign immunity that can immunize anyone against both proceedings and criminal liability, because any other immunity would be related to official functions and therefore would inherently be a qualified immunity. The two courts below, especially majority opinion of the Court of Appeal, relied on the phrase in the exercise of their powers under this Constitution. I am conscious that part of the President's role in the performance of their functions is the interpretation of the Constitution as to whether or not it gives them power to perform particular roles. Upon such interpretation, the President either acts or fails to act in the belief that either that power exists or does not exist. It would follow then that if proceedings were to be instituted against the President after the interpretation which is considered to have been wrong interpretation, then such proceedings would fall within the immunity contemplated in Article 143(2), in that it would be within the performance of the President's functions. There is no provision allowing or requiring the President to seek an advisory opinion from the judiciary before exercising their duties or before determining whether they have power to perform any official act. And in any event, this would generally blur the separation of power. Further, the two superior courts held that the President or the person performing the functions of the President is not above the law and should be amenable to the law if they act against the Constitution. The implication of this finding is far-reaching and therefore calls for a very careful analysis and consideration by this court. It is necessary to state that the Constitution has provided for how the President and the Executive in general can be kept in check through political accountability, with the provision that the President is liable for impeachment under Article 145 of the Constitution. The grounds for impeachment listed under Article 145(1) of the Constitution includes gross violation of the Constitution or any other law, commission of a crime under national or international law, or gross misconduct. This means that there is a clear avenue to check the President's conduct as acknowledged by this court, by the Court of Appeal in the case of Minister for Internal Security and Provincial Administration versus Center for Rights, Education and Awareness. With respect to legal accountability, the protection of the President from legal proceedings under Article 143 does not mean that President's actions or omissions cannot be challenged in court. Anybody or a party aggrieved by the President's actions or failure can initiate proceedings against the Attorney General, who by virtue of being the legal representative of the government in legal proceedings also represents the President. As such, pursuant to Article 156(4) of the Constitution, the exercise of public power by the President can be challenged in court of law by suing the Attorney General through an action of judicial review or constitutional petition, wherein a court may issue appropriate remedies. In effect, the findings of the two superior courts and the ramification of rendering Article 143(2) of the Constitution ineffective or superfluous. This is an interpretive path that, in my view, is not open to the courts. An interpretation of the Constitution that resorts to an amendment by a judgment is tantamount to judicial overreach. This leads me to the conclusion that the learned judges unfortunately fell in error in their interpretation and application of Article 143(2) of the Constitution by holding that civil proceedings can be instituted against the President or a person performing the functions of the President during the tenure of the office. I hold that civil proceedings cannot be instituted against the President or a person performing the functions of the President of the office of the President during their tenure of office in respect of anything done or not done contrary to the Constitution. Such proceedings can be instituted against the President by the Attorney General. Issue number 5 on public participation. Whether there was public participation. The issue was framed by the court with two components. The first relates to the role of INBC under Article 257(4), whether INBC is under an obligation to ascertain that promoters of a popular initiative have undertaken public participation during the collection of signatures. It is clear to me that there is no direct requirement arising from the provision of Article 257(4) that imposes an obligation on INBC to ascertain that the promoters of the popular initiative have undertaken public participation. Nonetheless,